Hello, everyone. This is my August 11th edition of Let's Talk Jackson. And this is to cover Jackson County Trial Day 4, or what actually happened, why Trial Day 4 did not happen, why the case was dismissed, and going over the State Tax Commission's order and also the Jackson County response. So first, before I begin this live, I have to provide a disclaimer that everything I say here are based on my own opinions, and these are not to be taken as absolute fact. Everything here are allegations and speculation and conjecture. So take everything what I say with a grain of salt, please. But as I promised the community many years ago, when big, massive things happen in our community, I will report on it, and I will try to provide my best, my opinion on these things in order to educate the public. But nothing that I state here should be taken as absolute fact. Now, I start this presentation with this slide that says "No more heroes," because there are absolutely no more heroes in this case. And when I say in this case, I mean in the Jackson County property tax assessment case. As many of you are aware, our case was dismissed, and I'm going to go over it soon. But this case was dismissed based upon actions from the Attorney General's office. It was not based upon the actual facts or findings of the court. And honestly, I believe that if this case actually went to the judge for her decision, there was enough evidence there for the judge to decide that they did violate state law when they conducted their property tax assessment. And this is based on the admissions that were heard in court during trial day 1, 2, and 3. Well, let's start this presentation. So now we have to ask first, why was this case dismissed? And this is my opinion on why the case was dismissed, and all of this is allegations and conjecture. So let me change my screen really quickly. Okay. So this is a flow chart that I've made of basically what was going on in the Jackson County court case in order to give everyone an easy way to follow the events, to follow where I'm coming from, in my opinion. And also, I was going to say, if anybody wants to leave any comments or have any questions during this live stream, please leave a comment on this stream and I will answer it when I can. Now, first, one of the critical dates that we must address is January 25th, 2024. On this date, this is when the Jackson County government was properly served, and the Jackson County Counselor's Office notified the Attorney General's office to direct all their communications to their office. This is basically because at this time, the Jackson County counselors were representing the Jackson County government, the Jackson County legislature, Frank White as Jackson County executive, and Gail McCain-Beatty as county assessor. And so they provided this email to the Attorney General's office stating that if they want to have any communication with the defendants, that they needed to be included on it. April 27th, 2024, this is the first known contact between Andrew Bailey and Sean Smith after the case was filed. Now, for those who do not know, Andrew Bailey is our current Attorney General of Missouri, and he also supervises and watches over the Attorney General's office of Missouri. And Sean Smith is a Jackson County legislator in Missouri as well. So on April 27th, there was a contact between Andrew Bailey and Sean Smith, and this contact occurred without the Jackson County counselors present. And we're going to go into detail over to what we know so far as to what that contact was. Next, on May 21st, 2024, the deposition of Sean Smith was taken. And this was a deposition that was requested by the Attorney General's office and was conducted. And during that deposition, the Attorney General's office asked Sean Smith multiple questions. And at that deposition, the Jackson County Counselor's office were present. Now, a deposition, for those who do not know, is basically a very, it's kind of like a interview before the trial. So at this time, the person who calls the deposition can ask the person who's being deposed any questions that they want to in order to get more evidence or insight on a matter. Then, on May 24th, 2024, the Attorney General's office attorneys directly contacted Sean Smith about his testimony without the Jackson County attorneys present, okay? This is when we start to get into why the Attorney General dismissed this case, because these contacts that were made are called ex parte contacts, and those are direct or indirect contacts with a third party or with a party without the other party's attorney present. So in this case, the ex parte contact was the Attorney General contacting Sean Smith directly, who at the time was represented by the Jackson County Counselor's office. And if this is confusing for anyone, again, please put a comment and I will respond to your questions. Then on May 29th, 2024, the Attorney General's office attorneys have a Zoom meeting with Sean Smith about his testimony without the Jackson County attorney present. As I stated before, at the time when this case was filed, Sean Smith, as a Jackson County legislator, was technically represented by the Jackson County Counselor's office, so the Jackson County attorneys. When the Attorney General's office had this Zoom meeting with Sean Smith, the Jackson County counselors were not present. And this goes into the basis of the motion for sanctions and why these contacts that Sean Smith had with the Attorney General's office was not only unethical, but violated the rules of professional conduct. Then we go to June 2nd, 2024. The Attorney General's office attorneys meet again with Sean Smith about his testimony without the Jackson County attorneys present. So this is another ex parte contact. Then June 10th, 2024, the Attorney General's office admits that they had multiple contacts with Sean Smith, including written communications, okay? And just for people to know, I'm getting all these dates from the pleadings that were filed on this case. So then we get to June 26, 2024. The Attorney General's office is deposed and the corporate representative confirmed. So on June 26, 2024, the Jackson County government deposes the Attorney General's office. Now, when you're deposing a corporation or a municipality, what usually happens is that they will, the corporation that's getting deposed is going to basically select a person to represent their corporation and to testify on behalf of their corporation. So on June 26, 2024, they had this deposition with the Attorney General's office. And this is what the Attorney General's office corporate representative confirmed. They confirmed that one, Sean Smith and Andrew Bailey discussed the Jackson County property tax assessment case in April. And two, that Sean Smith and Andrew Bailey discussed issuing a media statement about the lawsuit. Now, remember this part about issuing a media statement about this lawsuit, because that will be important later on. On July 3rd, 2024, the Jackson County government files a motion for sanctions, and the Attorney General's office files a response to this motion. So within this motion for sanctions, and we'll get into the details after I go through this flow chart, but they're basically stating that Sean Smith had ex parte communications with Andrew Bailey and the Attorney General's office, and thus this case should be either dismissed, or in the alternative, they should be granted an opportunity to depose Andrew Bailey in order to find out what was said during those communications. On July 10th, 2024, the judge grants this motion for sanctions and finds that the Attorney General's office counsel, so their attorney, Travis Woods, violated the rules of professional conduct and ordered the deposition of Andrew Bailey. Okay. So at this time, the judge made a specific finding that the Attorney General's office counselor, Travis Woods, did in fact violate the rules of professional conduct when he made this ex parte communication with Sean Smith. And so at this time, the judge has a whole list of remedies that she could have done. She could have dismissed the case. She could have excluded evidence. She could have excluded testimony. She could have done a lot of things. But in her order, she only ordered two things with the deposition of Andrew Bailey. She says that the deposition of Andrew Bailey could occur, but it has to be limited to, first, conversations and communications made after the case was filed between him and Jackson County legislator Sean Smith that pertained to this case, and two, that Andrew Bailey shall address the nature of the contacts, who was present for the contacts, and what was discussed during the contacts. Okay, so what I'm trying to really emphasize here is that the deposition of Andrew Bailey that the judge ordered was extremely narrow in scope. And I discussed this order with multiple attorneys, and multiple attorneys agree with me that a deposition of this nature would probably take at the most 30 minutes. It's not a big deal because of the narrow scope that was allowable under this deposition. And in layman's terms, the judge basically ordered the deposition of Andrew Bailey to only talk about communications with Sean Smith after the case was filed, that Andrew Bailey and Sean Smith had, and also the nature of the contacts and who was present during those communications, okay? And nothing else. On July 18th, 2024, the Attorney General's office files a motion to set aside the July 10th, 2024 order. So this is the Attorney General's first attempt to in this flow chart to prevent the deposition of Andrew Bailey. On July 23rd, 2024, the Attorney General Travis Woods withdraws from the case. Now, if you forgot, Travis Woods is the attorney from the Attorney General's office that had the ex parte communications with Sean Smith in May and in June. Okay. So on July 23rd, he withdraws from this case. July 24th, 2024, Jackson County files opposition to the Attorney General's motion to set aside. So in this motion, the Jackson County government is basically saying, hey, Judge, your ruling was correct. Disregard what the Attorney General says, because your findings about how an ex parte communication occurred and that there was a violation of the rules of professional conduct warranted this deposition of Andrew Bailey. On July 25th, 2024, the Attorney General's office attorneys then file a reply to the Jackson County's opposition. And again, we'll get into the specifics of these findings later on, but I'm just giving you the overview of the flow chart. July 26, 2024, the judge denies the Attorney General's office motion and again orders the deposition of Andrew Bailey. Now, if you guys been following me, you would know that the trial was set for August 9th. And so they had to conduct this deposition before August 9th, 2024. And so on July 26, 2024, the judge is like, nope, the deposition is going to happen. And remember, this deposition was very narrow in scope and only pertained to the communications with between Sean Smith and Andrew Bailey, and also who else witnessed these communications. On August 5th, 2024, the Attorney General submits its motion to dismiss the case for the Jackson County legislature defendants only. So on August 5th, in order, and this is my opinion, in order for the Attorney General's office submitted this motion to dismiss the case for the Jackson County legislature only, because they wanted to prevent this deposition from happening. But they stated in this motion that this was only for the legislature, that the reason why they're submitting this is because the legislature generally agrees with them that the 2023 property tax assessment was also flawed, and that they aren't an adversarial party, right? Which we can get into that discussion later. But they submit this motion to dismiss. And I believe it was to prevent this deposition from happening, the deposition of Andrew Bailey. August 6, 2024, two things happen. First, the Attorney General's office appeals the Jackson County judge's order to the Western District Court of Appeals, okay? So basically, they take the judge who's overseeing this case in Jackson County and appeal it to the Western District Court of Appeals, because the Western District Court of Appeals, if they disagreed with that judge's decision, they could overrule the judge's decision to prevent this deposition from happening, okay? Also, on August 6, 2024, the State Tax Commission issued its order against Jackson County. Now, this is when the State Tax Commission basically stated that they believe that the 2023 property tax assessments were flawed and ordered for the property taxes to essentially revert back to either the 2021, the 2021s, but this order only applies to properties whose values increased by over 15%, and we'll get into that. But that happened on August 6, 2024. Then on August 7th, 2024, the Western District Court of Appeals, they denied the Attorney General's writ. So basically, the Western District Court of Appeals basically stated that, hey, the judge in the Jackson County case did nothing wrong, and we're basically denying we're denying your appeal to prevent this deposition from happening. Also, on that date, the Jackson County government releases the statement against the State Tax Commission order. But other things also happen, and I have the timestamps here to show how interesting things are. So in the morning, I believe it's before 2:04 p.m. So first, on August 7th, 2024, the Western District Court of Appeals, they basically deny the Attorney General's office plea to stop this deposition from happening, the deposition of Andrew Bailey. At 2:04 p.m., the Attorney General's office appeals the Western District Court of Appeals decision directly to the Supreme Court. Then on 4:17 p.m., so 2 hours later, the Attorney General's office files a motion to dismiss all parties in the Jackson County lawsuit. And an hour later, they then file a motion to dismiss their appeal in the Supreme Court. Okay. So within 2 hours, within 3 hours, they basically decide that, you know what, we're just going to straight up dismiss this case. Their reasoning for dismissing this case is based on the fact that the State Tax Commission issued an order for the Jackson County government to basically calling the 2023 property tax assessments flawed and ordering that all residential properties that are not based on new constructions or based on improvements to their property, whose property tax assessments increased by over 15%, for those to be rolled back to a value that at most will be 15% of the 2021 values. And we'll get into that later. Then on August 8th, 2024, the Supreme Court and the Jackson County Circuit Court dismisses this case. Now, why is all of this important? And hold on a minute, I need to switch up everything. So why is all of this important? Why is the flow chart and everything so important? It's because of the fact that this case was dismissed not because of the Attorney General's office or the state of Missouri or the State Tax Commission lacking evidence to prove that the 2023 property tax assessments were flawed, but it was dismissed because the Attorney General's office did not want the deposition of Andrew Bailey to happen. Okay. Now you have to ask yourself the question, why did they not want the deposition of Andrew Bailey to happen? And that is when we get into the past, right? So this is the previous Missouri Attorney General, whose name is William Webster, and he was an Attorney General from 1985 to 1993. A lot of people don't remember William Webster, because I generally don't remember William Webster because I was too young when all this stuff happened. But William Webster essentially was on the track to becoming the next Missouri governor. He had a good as far as Republicans go, he had a good reputation. He was an okay attorney general, and a lot of people thought that he was going to win the election to become governor. But what happened was William Webster got into a little bit of trouble, okay? And why did he get into trouble? He got into trouble because under federal law and state law, it is illegal to use your political office staff, office equipment for political purposes, okay? The federal courts found William Webster guilty of 2 felony charges of conspiracy and embezzlement relating to abusing his position of attorney general by using his state staff and office equipment for political purposes. And because of this, he was sentenced for 2 years, like 2 years in jail, okay? Now, in our law, we have federal laws and state law that mandates this. Under federal law, it's called the Hatch Act, and under the state law, it's under the election, the chapter that governs the election laws, right? But these laws generally prohibit employees from engaging in partisan political activity while on duty in a facility or using federal or state property. Political activity is is activity directed towards the success or failure of a political party, candidate for partisan political office, or partisan political group. The statute carries serious penalties, including removal not only from federal or state office, but also from employment in general if you're employed by this federal or state agency, right? So this is my speculation about what occurred. There is a huge red flag here, and it all stems from this deposition. So let me go back to this. The deposition that the judge ordered, again, only talked about two things, right? They first talked about that for Andrew Bailey, the judge only ordered for Andrew Bailey to be deposed as to what he spoke about with Sean Smith, the nature of the contacts, and who were in the room with him while he was talking to Sean Smith. It was nothing more and it was nothing less. But because of the fear that Andrew Bailey had in taking this deposition, he caused this case to be dismissed. And there's no reason why it should have been dismissed if nothing happened, if nothing illegal happened, okay? But the reason why I believe that Andrew Bailey authorized, because in order for the Attorney General's office to dismiss this case, they had to have the authority of Andrew Bailey to do so. I believe the reason why he dismissed the case is because he was scared of being implicated in a state or federal crime. Because we have people like William Webster, who was found to violate these election laws and sentenced for 2 years in prison. Okay? So that's why I believe that this case was, this is the real reason why this case was dismissed. Now let's get into specifics, okay? So we're first going to talk about, in general, the motions for sanctions. And I call this the Andrew Bailey and Sean Smith gate, okay? So I'm going to go over things again from the flow chart in order to give you context, because everything that I'm saying here is pulled out of this motions for sanctions that was filed on July 3rd, 2024. So on July 25th, 2024, the Jackson County defendants, again, they served, the Attorney General's office served the Jackson County defendants, and the Jackson County counselors informed the Attorney General to include them onto all future correspondence on the matter, right? So basically, the county counselor's office is saying, hey, if you want to communicate with any of the defendants that are involved in this case, you have to include us on this correspondence. And the Jackson County counselors are correct pursuant to the rules of professional conduct that, and this rule is 4-4.2, that they were found, that the Attorney General's office was later found to be in violation of, okay? But that's what its basis is on, right? So in the motion, the Jackson County government argues that there was multiple ex parte contacts. And again, an ex parte contact is a direct or indirect communication about a pending case that occurs without the knowledge, consent, or presence of all parties involved, okay? And at this time, Jackson County legislator Sean Smith was a sworn defendant in this case. The defendant was the Jackson County legislature, okay? And he was named as a defendant because he is a Jackson County legislator. In the motion, it states that on April 27th, 2024, Missouri Attorney General Andrew Bailey met with Jackson County legislator Sean Smith in person. Now, the way that they proved this was they presented evidence that Sean Smith had on his Facebook that had a picture. Like, Sean Smith posted a picture with him and Andrew Bailey on his page that said, and this is a direct quotation, "Our campaign team meeting had a quick visit from Attorney General Andrew Bailey today. Both of us feeling great about our races, thankful for the efforts of the Attorney General in holding those responsible for the property tax debacle." Okay. And Andrew Bailey then liked this post. So the Jackson County government's attorneys basically stated that this is proof that they talked about not only using, well, first off, that they talked about the property tax assessment case, but, and this is where we're getting into the William Webster, whether or not this will violate law, is whether or not the Attorney General was using this case for his political benefit and not for the benefit of his, and not in order to do the duties of his office. Okay. Because if they make that link, then yes, it is a violation of state and federal law, in my opinion. On June 10th, 2024, the Attorney General's office stated that they had contacts with Sean Smith, including written communications. On June 26, 2024, the corporate representative deposition with the Attorney General's office basically stated, and I said this in my flowchart, that there was an in-person meeting between Andrew Bailey and Sean Smith that discussed the Jackson County property tax assessment case, and that they basically discussed the possibility of getting together for some sort of media statement about the lawsuit. Okay. So that's where the connection is, right? If it is found that the reason why Andrew Bailey filed this case or pursued this case was in order to do a political benefit rather than doing the duties of his office, then yes, this would, in my opinion, would violate federal or state laws pertaining to not using your political office for political purposes. Then on May 1st, 2024, the Attorney General that's when they took the deposition of Sean Smith. 3 days after they took this deposition of Sean Smith, the Attorney General's counsel, John Gritham and Travis Wood, so these are two attorneys that represent the Attorney General's office, they emailed Sean Smith and asked him if they would be willing to testify on behalf of the Attorney General's office. Sean Smith responded that he would accept service of the subpoena to testify in the trial and asked questions about whether he could sit through the trial. Travis Woods, the attorney for the Attorney General's office, then asked Sean Smith if he had time to meet over WebEx or Zoom to discuss his testimony, and they scheduled the meeting on May 29th, 2024. As an attorney, I need to tell you that these communications and these contacts, in my opinion, they do violate the rules of professional conduct. Now, at this time, Sean Smith is a named defendant in this case, okay? So that means, theoretically, he could potentially have information that are protected by the attorney-client privilege law. I mean, not law, but rule, the attorney-client privilege rule. Basically saying that, say if Sean Smith attended a closed meeting that just with the county counselors that discussed this case, anything in that closed meeting are attorney-client privilege communications that only need to stay inside the defendants and the attorneys, right, of the county. But because these communications happen, there is a great concern as to whether these attorney-client privilege communications were disclosed. Unlawfully disclosed. Next, on May 29th, or instead of unlawfully, I mean unethically disclosed. On May 29th, 2024, Travis Woods, which is the attorney for the Attorney General's office, and Sean Smith met for 40 to 50 minutes. Travis Woods asked Sean Smith, "Is there anything else you would want to give testimony about that was not discussed in your deposition?" They then proceeded to discuss about other topics outside of the deposition, like the resolution that the Jackson County Legislature passed, remedies, and Sean Smith's concerns about the assessment. And the reason why the Jackson County Counselor's Office is specifically bringing up these facts is because the only time the Jackson County Counselor's Office was involved in these communications was when Sean Smith had his deposition. The other times, the Jackson County Counselor's Office were not involved in these communications. They have no idea what Sean Smith said or Sean Smith disclosed to the Attorney General's office. Travis Woods then gave Sean Smith guidance about testifying in general. And they both, so Travis Woods and Sean Smith, agreed to meet again on June 2nd, 2024 for a more focused witness preparation. And Sean Smith sent an email to Travis Woods of a recording that was highly relevant to the Attorney General's case. Okay. Now, let me take a couple of steps back here on why this is so awful, in my opinion. I mean, this is, for me, even talking about this is giving me hives. So, say you own a company, say it's like a wood company, right? And you have a partner, and there was a case that was filed against your wood company. You know, say you sold wood chips, and say the state attorney general's office is accusing you of fraudulently selling wood chips. Okay, under the Missouri rules of professional conduct, they cannot take a representative of that company. So your partner, they could not take your partner and then have communications, like the attorney general's office could not have separate communications without the attorney present. And that's because your partner represents your company and is privileged and has the right to listen to attorney-client privileged communications, right? If that happened, then you would be, and when I say you, your company would be prejudiced because you wouldn't know what was disclosed. You wouldn't know what information your partner provided to the Attorney General's office. And so that's why we have this rule in place. Sean Smith could have had these communications with the Attorney General's office if he involved the Jackson County Counselor's office in these communications, but he didn't. And I don't understand why Sean Smith or the Attorney General's office, who, and this is the thing I'll say, if Sean Smith is not an attorney, so I understand, there's a bunch of rules and regulations when it comes to the practice of law. But the Attorney General should have known better. The Attorney General should have known that these communications violated the rules of professional conduct and should have immediately seized these conversations. And most importantly, Andrew Bailey, as the head Attorney General of Missouri, should have known that this conduct is improper. But nothing was said. They continued these conversations. And Sean Smith also provided evidence without the county counselor's knowledge pertaining to this case. And so basically in this motion for sanctions, the Jackson County government argues that these ex parte communications violated Rule 4-4.2 of the Missouri Rules of Professional Conduct. And this specific rule forbids a lawyer from communicating with a person the lawyer knows to be represented by another lawyer about matters within the scope of representation unless the lawyer has consent of another or of the other lawyer. So Sean Smith had the consent of the counselor's office to have these communications. He would have been able to. But even if he didn't have the consent, as long as the county counselor's office was present during these communications, this would have been 100% okay. But he didn't, and it violated this rule. And there's a comment on this rule that says that this rule applies even if the represented person initiates or consents to the communication. A lawyer must immediately terminate communication with the person if, after commencing communication, the lawyer learns that this person is one with whom communication is not permitted with this rule, basically stating that and this goes back to the April communication with Sean Smith. So them having this campaigning event talking about, their campaign, that's fine. But once Sean Smith talked about the attorney or the Jackson County property tax assessment case, Andrew Bailey was under a duty under these rules to immediately cease the communication. He should have basically told Sean, like, hey, I'm here to support you, but when it comes to this case, it's completely separate, and we just have to go by the law. I'm not supposed to talk to you about this case. I can talk with you about anything else, but I cannot talk to you about the case. But this didn't happen. This rule also has a comment that basically states that when a party sues a public official in their official capacity, such actions are treated as suits against the governmental entity that employs them. Okay, so what this is saying is that Sean Smith being sued because he was sued in his official capacity. I'm a little bit reversed. When the Jackson County legislature was sued, it basically means that Sean Smith was also sued in his official capacity as a Jackson County legislator. And so these rules apply to him specifically. And this comment continues stating that the real party in interest in an official capacity suit is a governmental entity and not the named official. Okay, so even though Sean Smith was the named official in this, he represented the Jackson County legislature that was a governmental entity, okay? And two, Sean Smith as a member of that's my point. Sean Smith as a member of the Jackson County legislature was a named official in this lawsuit, and thus Rule 4-4.2 applies to him specifically. Now, in the motion for sanctions that the Jackson County government filed in July, they basically asked for separate remedies, and I'm going to go through some of these remedies because I want the people to understand that the judge's order for the sanctions was not a harsh order. The judge could have straight up dismissed this case after making the filing that there was an ex parte communication that violated the rules of professional conduct, but she did not. And not only did she not rule that, but she also provided an extremely narrow scope for the deposition of Andrew Bailey. But let's get into it. The Jackson County government first asked that the Attorney General's office was required or should be required to produce information obtained through the ex parte contacts. And then they should also so basically the case law that they cite basically states that in order to determine what the proper level of sanction needs to be on an ex parte communication, then you need to know what the ex parte communication was. And so they asked for this information to be produced in order to determine what was the appropriate sanctions for these ex parte communications. And basically, these ex parte communications are communications that could divulge legal opinions, impressions, or strategies formed by the attorneys of the organization. And that if these were disclosed, then a more severe sanction needs to be imposed. They also allege that there was bad faith, that Sean Smith and the Attorney General's office and Andrew Bailey imposed bad faith in this lawsuit. They said that contacting a witness, and the witness is referring to Sean Smith, 3 days after the deposition to get more evidence and insight on the case is bad faith. And I have to agree. You know, like, they should have asked these questions to Sean Smith, or had these communications with Sean Smith during the deposition. They had time to, but they did not. And when I say they, I mean the Attorney General's office. They state that after May 29th, 2024, the meeting that Sean Smith had with the Attorney General's office made them change their exhibit list to include the Jackson County Legislature's resolutions, and that they did this based on the communications that Sean Smith had with the Attorney General's office, showing that these communications did in fact change the Attorney General's office strategy that they had in this case. So it was somewhat beneficial to the Attorney General's office. Next, they state that Sean Smith had access to information and attended closed sessions where litigation matters were discussed, and that the Attorney General's office was working with Sean Smith on a trial strategy against Jackson County. And so on the proposed remedies, they proposed that the judge should dismiss the case. So 1, dismiss the case. 2, make Andrew Bailey sit for a deposition and produce notes and communications about the ex parte communications. 3, disqualify Andrew Bailey and the Attorney General's office from representing the state of Missouri and the State Tax Commission on this case. 4, preclude Sean Smith at testimony at trial. And 5, preclude any evidence Sean Smith provided to the Attorney General's office during the trial, or during this, when the case was filed. I state that because the judge could have granted any one of these, but the judge basically said, hey, to the other side, produce all the evidence of the communications that you had with Sean Smith, and I'm going to allow the deposition of Andrew Bailey only on this extremely narrow scope, okay? Now, on the same day, the Attorney General's office responded to the Jackson County's motion for sanctions. They basically stated that the meeting between Andrew Bailey was arranged by campaign staff, attended by candidates and their campaign staff, and for campaign purposes. Which I don't understand why they said this, because that's when we're getting back into the whole issues of federal and state law, where you cannot use your political office, you cannot use office employees, office resources, office equipment for a political purpose, right? They then state that the main purpose of the meeting was not to discuss a lawsuit, and that this order would interfere with the Attorney General's ability to run the Attorney General's office and campaign for his office, which I have to say, to that reason, that's a bunch of hogwash, because this deposition, I'm telling you, I've been an attorney for 10 years, okay? This deposition would take probably 30 minutes, at most an hour, based on how limited this scope is. And when I say an hour, like, you really have to be pressing it with an hour. So on July 10th, 2024, again, the judge issues her order for sanctions. She found that the Attorney General's office violated, their counselor, Travis Woods, violated Rule 4-4.2, which is the ex parte communications rule, and ordered the deposition of Attorney General Andrew Bailey. And again, this was only limited to conversations and communications made after the case was filed between him and Jackson County legislator Sean Smith that pertain to this case. And 2, that Andrew Bailey shall address the nature of contacts, who was present for the contacts, and what was discussed during the contacts. That was it. Okay. On July 18th, 2024, the Attorney General files a motion to set aside the judge's order. And this motion is extremely long, okay? But I pulled the facts that I thought were relevant to this case because there were some things that the Attorney General argued that I believed just they weren't good arguments, man. They weren't good arguments. But their argument basically was that there was no need for the Andrew Bailey deposition. And they first state that this was a brief, casual meeting between two elected officials and their campaign staff, unrelated to the lawsuit, but where at most, a passing remark was made about the lawsuit, right? Now, with that argument, if this is true, why is Andrew Bailey trying to hide from this deposition? Okay, it makes no sense. Second, they argue the Attorney General's office corporate representative provided all the material details about this communication. Now, that argument is incorrect for several reasons, and that's because in the Attorney General's corporate representative deposition, and this was stated in the pleadings that were filed, the corporate representative states that he was not there during these communications, and so he didn't know who was in the room or what the nature of the contacts were during the communications between Sean Smith and Andrew Bailey. The next argument that the Attorney General argues is that Andrew Bailey's testimony is not relevant to matters in this case, that the order violates Andrew Bailey's freedom of speech, and that there was insufficient evidence that the Attorney General's office attorney knew that Sean Smith was represented by the Jackson County attorneys. Okay, that's their argument. And also, they submitted an affidavit from a person that was a part of let me make this right. She was a part of Sean Smith's campaign, right? In order to prove that these communications were irrelevant. And honestly, after reading this affidavit, everything just seems more suspect. And I'm going to read to you some of the parts of this affidavit that I found interesting, okay? So she states, as a volunteer for the Sean Smith for Congress campaign, I attended a meeting at Sean Smith's home, blah, 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 on April 27th, 2024. The purpose of this meeting was to discuss campaign business, events, volunteer recruitment, and other such issues that come up in a campaign for public office. During the course of this meeting, Sean Smith mentioned that Andrew Bailey was in town for a campaign event and would be stopping by at some point later in the morning to introduce himself to Sean. Andrew Bailey greeted each of us from the campaign and then stood in the same room with his campaign aide while having a discussion with Sean Smith. I did not listen to the entire exchange between the two men, as some of us in a nearby table continued to wrap up some campaign issues. There was mention of good luck on the trial by someone in the room as Andrew Bailey was heading out the door, although I do not remember who made the remark. This is the affidavit that was submitted by a person who, honestly, I don't understand why they use that lady's affidavit, because in that affidavit, it proves that they did talk about the trial during the campaign event. So then again, on July 23rd, 2024, the Attorney General's attorney, Travis Woods, he files a motion to withdraw from this case. July 24th, 2024, the Jackson County files suggestions in opposition to the Attorney General's motion that they filed remember, the Attorney General's office filed a motion to a motion to set aside the judge's order to conduct the deposition of Andrew Bailey. And so they submitted their paperwork in response to that. And I have this as a direct quotation because I thought this was interesting. This counselor quotes George Orwell, which I found hilarious, okay? Because if George Orwell lived in Jackson County, George Orwell would not be on the Jackson County counselor side. But basically, he states, war is peace, freedom is slavery, ignorance is strength, right? Basically stating that the Attorney General's arguments are so topsy-turvy, what's the word to find for it? It's so ridiculous in nature that it doesn't make any sense in face of reality of what happened, that it should be ignored. So they argued first. They first talk about the Attorney General's quote, which stated, brief casual meeting between two elected officials and their campaign staffs unrelated to the lawsuit, but where at most a passing remark was made about the lawsuit. The Jackson County Counselor's Office argues that first, this conflicts with prior statements of the Attorney General's office, right? So remember, the Attorney General's office had the corporate rep deposition where they talked about these ex parte communications. And during this deposition, this statement that it was a brief passing conversation that had nothing to do with anything, at most it was innocent, is in direct conflict with the corporate representative's testimony as to what was communicated and the nature of the communication. But specifically, they say that the Attorney General's office during this deposition first did not identify their contact with Sean Smith. So during this deposition, and I don't have the transcript of this deposition, so I'm just right now, I'm just speculating. These are all allegations, but this is based on my experience as a person who's given multiple depositions. I'm assuming during this deposition with the Attorney General's office corporate representative, they first asked the question, did you have any ex parte communications? Yes or no? They probably said no. Did you have any ex parte communications with the Jackson County legislator? They probably said no. They probably didn't identify, right? And then what they did was they were like, Exhibit A, here you go. Isn't this a picture of the Attorney General's office the Attorney General, Andrew Bailey, meeting with Sean Smith? And in this caption, does it state that it had to do, a part of it had to deal with the property tax assessment, right? And then looking at this, the corporate representative had to say yes. But when they say that the Attorney General's office first did not identify their contact with Sean, that's what I speculate as to what probably happened in the deposition. Then they say second, after the Attorney General's office was pressed about whether or not these communications happened, they then admitted to it. They state that the Jackson County government provided evidence that established the meeting between Sean Smith and Andrew Bailey. And then the Attorney General's office corporate representative admitted that they met with Sean and Andrew Bailey talked with Sean about this lawsuit. Then they specifically, the Jackson County Counselor's Office then attacks the Attorney General's argument that it was a quote unquote passing remark. Okay. They say if this was true, then why not provide the full account of the conversations and communications made after the case was filed between him and Sean Smith and address the nature of the contacts, who was present for the contacts, and what was discussed during those contacts, which I have to agree. If everything was, if everything was like, if there was no attorney-client privileged information disclosed, if nothing illegal happened, if everything was PG, then why not answer these questions, right? The Attorney General's office to this day has still not disclosed this information, by the way. They then state that, again, that the court's order does not violate anyone's freedom of speech, and that the Attorney General's arguments are an attack of the constitutionality of the Missouri Rules of Professional Conduct, which I agree, right? Like the rules of professional conduct, the Missouri Rules of Professional Conduct basically say, like, Sean Smith and Andrew Bailey could have had a conversation about anything, and that would have been fine, except this case, because there is a what is it called? Because in this case, since Sean Smith is a defendant in this lawsuit, since there is such a high risk of him to disclose attorney-client privileged information, you are not allowed to have these discussions with him unless his counsel is present, which they were not, right? And so for the Attorney General's office to argue that this violates Andrew Bailey's freedom of speech, if the judge actually agreed to that, then the judge would be saying that the Missouri Rules of Professional Conduct are unconstitutional, which is not going to happen. Next, the Attorney General's office. They then finally argued that the Attorney General's office should have read the Rules of Professional Conduct before they filed the lawsuit. And yes, and I can tell you, as an attorney, we have to take a separate test that's specifically about the rules of professional conduct in order for us to be barred as an attorney, right? And not only that, every year we have to dedicate hours of study reviewing the rules of professional conduct. So for the Attorney General's office to state that, you shouldn't punish us for violating this rule because we really didn't know it, it was a bad argument on their behalf. Now, on July 25th, 2024, the Attorney General's office replied to the Jackson County government's suggestions in opposition to the Attorney General's arguments. And they basically only had one argument. This reply was only like 3 pages long. And their argument was the Jackson County Counselor's Office has limited authority and did not represent Sean Smith, and therefore Rule 4-4.2 does not apply to Sean Smith. That was their only argument. Okay. Then, of course, we're getting to July 26, 2024, where the judge denies the Attorney General's motion to set aside the sanctions order. Okay. And I also have to state that the judge's order was a generic order. Okay. Basically stating that I've reviewed this motion and based upon what was said, I denied this order. And the reason why it was generic is I believe, this is my speculation, is the judge didn't need to say anything else to support her findings on this order. So next, August 5th, 2024, the Attorney General's office then submits a motion to dismiss the case specifically for the Jackson County Legislature, right? So July 26, 2024, the judge says, no, the deposition has to continue. The deposition has to happen. You have to depose. You have to allow the Jackson County Counselor's Office to depose Andrew Bailey before August 9th, 2024, which would technically be trial day 4. Okay. On August 5th, 2024, the Attorney General's office moves to dismiss its case only to the Jackson County Legislature, right? And they state that they're submitting this motion to dismiss because the Jackson County Legislature and the AG office are not adversarial parties, but they wish to maintain other cause of actions against the other defendants, and that they concluded that the Jackson County Legislature, they're not a necessary party for relief if the plaintiff prevails on the merits. And I have to say, man, that's an argument. Do I think it's a good argument? No, but that's an argument. Knowing the case law behind necessary parties, yeah, the Jackson County Legislature is a necessary party. Did they permit the funding of Tyler Technology in order to do this assessment? Yes. Do they have specific information regarding the property tax assessment? Yes. Did they have some nature of oversight with this property tax assessment? Yes. And that's shown through, one, they provided them funding, and two, during this whole property tax crisis of 2023, they were producing resolutions that stated their position, right? How they were against the 2023 property tax assessment. They were necessary parties in this case in order to determine whether the Jackson County government violated the state statutes when it came to them conducting the 2023 property tax assessment. Then on August 6, 2024, the Attorney General's office appeals the judge's order of sanctions to the Western District Court of Appeals. So basically, as I stated before, on August 6th, they took the judge's decision and they went to this Western District Court of Appeals, which is the court that oversees the Jackson County Circuit Court, and asked the Western District Court of Appeals to review the judge's decision to see if they will overturn the judge's decision. And of course, on August 7th, 2024, so less than 24 hours, the Western District Court of Appeals issues an order basically denying the writ, basically saying that the judge who's overseeing this case made a proper order, and that her order is not unconscionable or not unreasonable, and that they had to do the deposition of Andrew Bailey. But also remember, on August 6, 2024, the State Tax Commission, that's when they issued their order against the Jackson County government, basically stating that their assessment of their 2023 property tax assessment had multiple flaws, and that any residential property that was not a new construction and did not have improvements, that they could not have their property tax assessment increased by over 15%. And we'll get into that specifically. So on August 7th, 2024, after the mandate from the Court of Appeals in the Western District comes down, basically saying that the judge in the circuit court case, like her order was within the rules, that's when the Attorney General then files a writ asking the Supreme Court to review. And I heard from insiders in this situation that the Attorney General's office had on good information that the Supreme Court was also going to deny the writ. And that's why we have these series of, I call it the 3 hours, right? We're on August 7th, 2024. At 2:04 p.m., the Attorney General filed a writ with the Supreme Court. Then 2 hours later, at 4:17 p.m., the AG then files a motion to dismiss all parties, not just Jackson County legislature, but all the parties in the Jackson County case, okay? Then at 5:09 p.m., the AG files a motion to dismiss the Supreme Court case that they filed 3 hours prior, okay? On this day, too, the Jackson County government released a statement stating that they are against the State Tax Commission's order and that they would fight it. And on August 8th, the Supreme Court and the Jackson County Court dismisses both cases with prejudice. And what with prejudice means is that the state Attorney General's office and the State Tax Commission cannot bring up another case against the Jackson County government relating to the 2023 property tax assessment. So we cannot use the courts anymore to provide us with a remedy. So that's it. It's done. And I don't think it's going to be appealed because of the fact that it was the Attorney General's office that dismissed this case. Okay. So I got a comment here from Terry Smith who says, sounds like the citizens of Jackson County have been left out to dry by Bailey and Tyler Industry walks away without any accountability for their assessment circus they provided. Yes, that is 100% true. Not only did we lose our statutory argument against the Jackson County government for an improper 2023 property tax assessment, but we also lost our arguments of negligence, fraud, Missouri Merchandising Practices Act's claims against Tyler Technology, which, in my opinion, could have produced a multi-million-dollar a finding from the jury because the facts were there. And this is my opinion. I attended all 3 days of trial, and you had Gail McCain Beatty, in my opinion, from what I heard, basically state like, yes, I didn't do these things pursuant to the statute, but I still allowed this assessment to proceed, right? That not only shows that she had awareness that she was conducting the property tax assessment incorrectly, but she knowingly, she knowingly knew that the process was fraudulent, allegedly, and she still allowed it to continue. And I believe that if there was a Jackson County jury, they would have found that they should have paid. Tyler Technologies and the Jackson County government should have paid for their actions. But now we don't have that because of the Attorney General's office, Andrew Bailey, actions with Sean Smith, and they should have known better. They should have known better. It makes me mad, and I know that with a lot of other people that have been following this, it makes them angry. I'm angry too because we're not going to receive justice. We're not going to receive justice. I mean, I know that some people in the Jackson County legislature are claiming that the State Tax Commission order is a win. It's like, yay, we won. But it's not a win. It's not a win because the Jackson County government is going to fight it. And now we have this whole question of, is this order going to be overturned? Because I'm going to get into this right now, the State Tax Commission order. Because in the response, there are some things in there in the order that's like kind of like, that's kind of true. So let's get into it. So the State Tax Commission on August 6, 2024 puts out an order and basically states that they first say that they have the authority to make this order under Missouri Statute 138.410, which states that the State Tax Commission has general supervision over all assessing officers of the state and county boards of equalization and appeal, and can issue orders designed to enforce law and ensure uniformity. So they're saying that under this specific statute, they're able to do what they're about to do in this order, which for me, it's a little bit questionable if they can, but bear with me. Next, they state in this order that the Jackson County Executive is responsible for the administration of affairs of Jackson County and has the power to correct mistaken or erroneous assessments, which is true. Then they state that they then go into the laws that the 2023 property tax assessment had to follow, which is under Missouri Statute 137.115. And if you've been following my lives, this is going to sound repetitive, but I have to go over this because it's important. So first they say, before an assessor may increase the assessed valuation of any parcel of real property by more than 15% since the last assessment, the assessor shall conduct a physical inspection of such property, okay? 2, if a physical inspection is required, the assessor shall notify the property owner in writing and provide the owner written notice of the owner's rights. 3, The property owner may request that an interior inspection be performed during the physical inspection. 4, the owner shall have no less than 30 days to notify the assessor of a request for an interior inspection. 5, mere observation of the property shall not be considered sufficient to constitute a physical inspection. And 6, all these sections are mandatory and not merely directory in nature. In the event that the property owner appeals an assessment, if the assessor fails to establish that proper notice was given and that a physical inspection was performed, then the property owner shall prevail as a matter of law. And as I stated in my prior lives, during Jackson County Court or Jackson County Trial Day 1, 2, and 3, there, in my opinion, there was enough evidence established that the Jackson County government didn't do this. Okay. And if you want more information, please watch my prior lives about this. Next, the State Tax Commission basically stated that they have consistently ruled that property assessment increases must not exceed 15% from the last assessment when the assessor fails to comply with the notice and inspection provision of the statutes. They then issued these findings, okay? First, the Jackson County government failed to give proper notice to property owners and failed to perform required physical inspections when it conducted its 2023 property tax reassessment. 2, this resulted in mistaken or erroneous assessments and taxes that were mistakenly or erroneously levied or paid in 2023 that, and then they provide a list. First, Jackson County did not notify in writing to most property owners whose assessed values increased by more than 15% that a physical inspection was required. 2, Jackson County did not notify most property owners that a physical inspection was required and did not provide the owner clear written notice of the owner's rights relating to physical inspection during or including the property owner's right to an interior inspection during the physical inspection. 3, many notices sent to the property owners were undated and did not include percentage change in the assessed valuation and did not provide property owners 30 days to notify the assessor of a request for an interior inspection. And then 4, Jackson County officials did not comply with the physical inspections pursuant to the Missouri Statute 137.115 with its parcel by parcel reviews. So this one is specifically talking about how you cannot say that you conducted a physical inspection when you drive by the parcel, right? They're saying you have to conduct a physical inspection specifically that will comply with this statute of 137.115. And then they make specific findings with the Jackson County Board of Equalization. And they state Jackson County conducted a Board of Equalization appeals in such a manner as to 1, provide taxpayers with insufficient or misleading information as to the appeal process. 2, provide insufficient physical accommodations, making it difficult, if not impossible, for some taxpayers to pursue their appeal rights. 3, incorrectly telling property owners that the burden of proof was on the property owner in the Board of Equalization hearing. 4, refusing to recognize evidence as to valid comparable sales provided by some taxpayers. 5, undue interference by the Jackson County Assessor's Office in the nature of the Board of Equalization, in the affairs of the Board of Equalization. 6, overall denial of due process to Jackson County taxpayers. And finally, they made a finding that the failures of Jackson County were widespread, systemic, and affected at least 75% of parcels county-wide. So they issued an order, and the order had 5 they ordered the Jackson County government to do 5 things. So first, they state that the Jackson County assessing officials shall correct the 2023 assessment rule to reflect assessed valuations for all residential parcels, excluding new construction or improvements that do not exceed 15% since the 2021 reassessment. So first, they're ordering them to correct all parcels or all residential parcels besides new construction or new improvement parcels that basically exceeded the 15%. So they have to roll that back. Second, that all pending 2023 property appeals, so these are appeals that are currently pending before the Board of Equalization and State Tax Commission, shall be reassessed by a value that does not exceed 15% since the 2021 reassessment. So they're stating that if you right now have a pending appeal with the Board of Equalization, the Board of Equalization can only at most increase your property tax assessment bill by 15% at the most. Third, they ordered that within 30 days of this order, and this order was issued again on August 6, 2024. So that's on or before September 5th, 2024. Jackson County shall review all residential property stipulations that have been submitted to the State Tax Commission for review and shall notify the State Tax Commission of all stipulations that exceed the 15% increased value. So if you made a stipulation with the Jackson County government as to what your property value would be, and it was above 15% in comparison to your 2021 value, the State Tax Commission basically states that those also have to be rolled back to not exceed 15%. Next, they ordered that the 2024 assessed value shall be the same as the 2023 assessed values, excluding increases due to new construction or improvements, okay? And finally, they ordered that the Jackson County government shall take all necessary actions to ensure future compliance with 137.115. Okay, that's what the order specifically stated. Now, in this provision that they're arguing for that gives them authority, you can look this up. It's 138.410. From what I read is basically, since the State Tax Commission issued this order, if the Jackson County government doesn't comply with this order, then the Attorney General's office can again sue the Jackson County government for failure to comply with this order, and we'll be all back in the same rodeo show again. But it would only be for failure to comply with this order. It could not be for negligence or fraudulent practices regarding the 2023 property tax assessment. Finally, let's go over our favorite man, Frank White, and Jackson County government's response to the State Tax Commission order. So in their response, they basically reject the State Tax Commission's order. They say that it's inaccurate and dangerously politicized, that the litigation tactic from politically motivated actors who are ill-informed and acting in bad faith. They said that their reassessment plans for 23 and 24 were reviewed and approved by the State Tax Commission, and that this order came without any hearings or evidence. And now that, and with this hearings order, they now state, so the State Tax Commission now states that they failed to meet statutory requirements, basically meaning that if the State Tax Commission initially believed that they failed to meet statutory requirements, they would have given this order a while ago, and they wouldn't have reviewed or approved their assessment for 23 and 24. Is this true? I don't know. I don't have the information in front of me, but that's what they're arguing. Next, they state that consequences of the order would be disastrous for our community. They state that that it will cost local schools $1,500 per student, that libraries, fire departments, and cities would face serious budget cuts and negatively impact the essential services our residents depend on every day. This is the Jackson County argument. Next, they have a quotation in here that says, fairness in property assessment is not just a legal duty, but a moral obligation. That's a direct quote from this release. Okay, that's what they believe. They state that when one property is undervalued, others must pay to fill the gap. Gail McCain Beatty also released a statement where she said, for too long, many homes have been undervalued, forcing others to overpay. We cannot and will not allow this injustice to continue. We will do our jobs and uphold the law by assessing properties at market value, regardless of these political games. And I have to state for the record, this is the same person who testified on trial day 3 that she did not comply with the county ordinance when it came to property tax reassessments or with the state statute when it came to the property tax reassessments. Okay. And also, she stated on the stand that she followed the spirit of the law. Okay, that after it was proven that she did not comply with the law. I just have to say that for my own sake. Finally, or not finally, but we also have Frank White's statement on this. Frank White states, our mission is to provide a fair and equitable process where no one pays more than the law requires. This reckless order is harmful not only to taxing jurisdictions, but also taxpayers, while fixing decades of mismanagement hasn't been easy. We are committed to fairness and will continue working every day to achieve it. Actions like this do immense harm to our communities. So then they end their statement basically saying that this will have a disproportionate impact on Black and Brown communities. They state that the issue, and this is a direct quotation because I had to pull this. The issue of unequal property assessments has long been a critical concern, particularly in its disproportionate impact on Black and Brown communities. Research consistently shows that these communities often face higher property tax assessments relative to their home's market value compared to predominantly white neighborhoods. This discrepancy can exacerbate economic inequity or inequality and contribute to systematic disadvantages in housing and wealth accumulation. Okay. And with that, I have to do this. I'm going to pull up these slides. So first, this is what the Jackson County government did, okay, in their 2023 property tax assessment. The areas that got the most, that increased the most, right, are the areas that are more blue, okay, and the areas that are more yellow had the least increases in the property tax assessments, right? So they're arguing that if we roll back these property tax assessments, it's going to provide all this inequity to Black and Brown communities because usually Black and Brown communities are taxed more. Let's see. If we look at this slide, minority population by block group and poverty rate by block group, right? This is Jackson County right here on both of these, right? Now look at the orange sections that are in both of these maps, right? And then look at this, which basically shows that argument that Black and brown communities are going to be disproportionately negatively affected by this, for me, is deception and a manipulation for what happened, which Frank White and Jackson County government, they targeted the minority and poor communities of Jackson County and increased their property, increased their assessed values disproportionately compared to areas that are not, that don't have high concentration of minorities, or areas that are in areas that are affected by poverty more so than wealthy areas. And that's proven by this graph right here. And I honestly just find the whole situation disgusting. And that's why at the beginning of the slide presentation, I have here that there's no more heroes, because the Attorney General has failed the people of Jackson County. And we really don't have any more redress. We just have to hope that the state tax commission order can stand. But there's so many issues that could go wrong with the state tax commission order. And I really can't speak to it because I don't specialize in municipal law, right? But for instance, if the state tax commission's regulations required a hearing or required a presentation of evidence in order to submit this state tax commission order, and they didn't follow their own procedure, then their own order could be reversed. And then we would just be stuck with the 2023 property tax assessment that the Jackson County government has already admitted did not comply with state statute. And so I feel horrible because so many people have spent so many hours of their life worrying about the state tax commission or state tax assessment. You have so many people who spent hours preparing for this case, only for this case to be dismissed, not because of the evidence that was presented during the case, but because of the actions, the unethical actions that were taken by the Attorney General's office and Sean Smith. And so, yes, everyone should be mad about this. Everyone has the right to be mad. We shouldn't have lost this case. But that's what we have right now. And yeah, I wish I could have a more positive note, but I'm not positive about this. I'm glad the State Tax Commission submitted its order, but they could have submitted this order last year. They submitted this order on August 6th because, in my belief, based on my speculation and conjecture, because the AGs, maybe they were under pressure by the AG's office so that they could prevent the deposition of Andrew Bailey, because Andrew Bailey might have violated a federal or state law. So, yeah. That's my presentation. If anybody has any questions, please leave a comment right now, and I will take any questions about this. Otherwise, after a minute, I'll just I'll log off. But if you're watching this as a recording, then still leave comments and I'll just get back to them at a later time. But right now, if you have any questions or comments, please share them and I will respond to them. But, I'm tired. I personally think that every Jackson County resident should be mad at everyone. Everyone failed us. Everyone failed us. And I remember on trial day 2, there were so many individual witnesses. There were like 15 people who had to, who were individual citizens who had all these compelling stories about how this property tax assessment increased their homes' values to the point that they were not able to pay, or pay their property taxes, and so that they would have to sell their house, right? And they had to prepare for that testimony, and all that testimony was all for naught. Dana asks, why won't Bailey go like sit for a deposition? I don't know. That's the key question here. That's the key question. And in my belief, based on allegations and speculations and conjecture, is there might be an issue where Andrew Bailey broke the law, a criminal law, and he's trying to avoid that. Dana states, I am mad. Is there anything we can do about this? No. The only recourse that we had was through the Attorney General's office and the State Tax Commission. And with the Attorney General's office dismissing the case, the judge dismissing the case with prejudice, which I state, the judge dismissal with prejudice, like usually judges will dismiss cases with prejudice if the plaintiff's party moves for dismissal during a trial. Okay, so that's standard. That's nothing that's like, oh, is there corruption here? That's standard. And I'm telling you again that this judge was fair and she was reading everything. And no one should be mad at the judge. People should be mad at the Attorney General's office for this one, for Andrew Bailey. When in regards to Sean Smith, he's not an attorney. He doesn't know the law, but he should have known better, man. He should have known better. So no, there's nothing that we can do about this. All we can do is hope that the State Tax Commission order stands. But there are so many there's so many factors here that I don't know, because I'm not an attorney that specializes in that specific type of law, that potentially they could find that the State Tax Commission order was improper because it violated certain steps, and that could overturn the order, and then we would be stuck with the 2023 property tax assessments. Yeah, Terry states, I was so excited about Sean Smith running, and now I feel devastated and disappointed. I do too. And the thing is like, I wish, you guys, if this teaches you anything, is if you're involved in a litigation and you're concerned about anything, please talk to your attorney first. Talk to your attorney first before you do anything, because Sean could have done this. He could have talked to his attorney and been like, hey, Andrew, I might have communications with Andrew Bailey. Is there anything that I should be aware of because of this Jackson County lawsuit? And I'm pretty certain that the county counselor's office would have advised him that he's under a duty not to, well, not him, but the Attorney General's office is under a duty not discuss with him anything about the case without counsel present. Okay, so this all could have been avoided. It all could have been avoided. Dana states, what is the possibility that the state tax? What is the possibility that the State Tax Commission's order stand? I don't know. And I say that because I don't know the rules and procedures go with the State Tax Commission's order, right? I know that the State Tax Commission oversees the county assessor's department, like the county assessor of every county, right? And theoretically, yeah, they do have the power to do this. Now, did they follow the correct procedure in order to do this? I don't know. If they didn't follow the correct procedure, then theoretically, courts could overrule their order. And that's the issue. Lisa states, as of 2 weeks ago, he didn't have his own attorney. No. So Sean Smith, as as a Jackson County legislator, he was represented by the Jackson County Counselor's Office. So he did have an attorney. The Jackson County Counselor's Office represented him. And so he could have asked the Jackson County Counselor's Office. Also, his own office as Jackson County legislator has access to attorneys within that office. And he could have asked any attorney in that office, and they would have, I'm just hoping that they would have advised him not to. I personally would have advised him not to speak to Andrew Bailey, not to even be in the same room with the Attorney General's attorneys without the Jackson County Counselor's Office present. Lisa states, and the county will fight this order using Jackson County attorneys who are paid by our taxes. Yes. And I'm sorry, let me state this clearly for people. And the county will fight this order using Jackson County attorneys who are paid by our taxes money. Yes, they will. We all lose. We all lose this case. Claire states, and in 2025, we have a reassessment all over again if we can manage to hang on. Yeah. In 2025, there's going to be a reassessment. And I heard from some people that Gail is going to do the same thing that she did to us in 2023 and 2019. So hold on, everybody. Hold on. Because we might have another crisis in 2025. And there's nothing that we could do about it. Dana asked, when will we know if the state tax commission action sticks? I don't know. I'm assuming, and I say assuming, I don't know this for sure, but I believe that I believe that the Jackson County government might file another lawsuit against the state tax commission, stating that their order is invalid or improper. And so as with any litigation lawsuits, they usually take a year or two to decide. So we might not know if the state tax commission order sticks until next year or the year after that. However, since the state tax commission did order this, that means that at this time, the Jackson County government has to follow their order, okay? Unless something else happens. But generally speaking, on August 6, 2024, when the state tax commission issued this order, the Jackson County government has to comply. And in the order, it states that they have to comply within 30 days. So Lisa says, I also heard that Gail said that the 2023 appeals cannot be resolved until 2025. Not anymore. The state tax commission order basically states that in regards to the appeals, none of the properties who are under appeal right now, the BOE can't mandate a property tax assessment that exceeds 15%. So what I think will most likely will happen is the Board of Equalization will just send out a blank correction, basically correcting the people who are now in appeal and having their new value at the 15% level. Terry asked, what effect does this have on senior citizens and freezing their assessments? That's why I'm telling everyone, get your freeze in now. This order is official right now. It's official. And so that means that whatever say if your property tax assessed value was increased by 120%, okay? What they're saying is that has to roll back to a percentage that does not exceed 15%. And so if you apply for your property freeze right now, it will be locked in that level. The assessed value that does not exceed 15%. So please, if you're able to apply to the senior tax freeze, please apply, because that will if a 2025 property tax crisis happens, then it will not affect you if you have those freezes in. So please apply. Lisa says, I'll believe when I see it. Well, I mean, according to law, when that order is, so basically, when the order is issued, it is like right then and there, it has to be complied with. They give them 30 days. But what, the Jackson County government can file an emergency a restraining order on this order, basically stating that the order itself violates its Missouri law, and have that order be frozen or set aside until a judge hears it. Which there's a massive possibility that might happen. Dana asks, since this has been dismissed, does that mean Tyler Technologies is off the hook? Will the April 2025 court date be dismissed? Yes. Yes, it's already been dismissed. Tyler Technologies is 100% off the hook. They have made their $17 million, and they're not going to receive any sort of punishment or any sort. They're not going to receive any negative ramifications for what they did to the Jackson County public in their 2023 property tax reassessment. Okay, so they're 100% off the hook, and that is what it is. And I feel horrible about it too, but there is something we can do. Okay, there is something we can do. This year, Elad Gross is running for Attorney General on the Democratic side. Please, if you can, vote for Elad. Okay, vote for Elad so at least we can have a competent Attorney General. Because what Andrew Bailey has done to the Jackson County people is unconscionable. It's so bad. And I say this as an attorney. There's levels to this, okay? No reasonable attorney would have communications with a represented defendant without its counsel there. And even though the rules say that you can have written consent and it'll be fine, I personally still wouldn't even have the communications if I had written consent. I would need the attorney there in the room. These are very serious, very serious. This is a very serious violation of the rules of professional conduct. Lisa says, "Thank you, Andrew Bailey." Sarcasm. Yes, I know. And what's just so crazy about this whole entire thing is I read somewhere that Andrew Bailey filed over 70 cases and he's lost all of them. And this could have been the one case that Andrew Bailey could have won. Why? And I'm saying this because I was there. You can read my tweets. You can look at my lives. I was there for all 3 days of this trial. The Jackson County government, through Gail McCain Beatty, admitted on the stand that she did not comply with all the provisions of 137.115 and the Jackson County ordinances that pertain to the 2020 or pertain to assessments in general. She stated that on the stand. On face, we won this case. We won this case. We won this case, but we lost this case. And we lost this case not because the Jackson County government did not do anything improper, but it was because of communications between Andrew Bailey and Sean Smith. And Andrew Bailey is doing everything that he can in order to avoid having any liability, criminal liability with regards to those communications. In my opinion. I will stay live for a minute if anybody has any more questions or comments. And if not, I will just end the session right now. Dana asks, how discouraging after all the blood, sweat, and tears we've all gone through. Yes. Yes. It is discouraging. It is. Claire says, shaking my head, speaking of elected, is there any reality of moving away from the appointed possessor for assessor ever? That's a great question, Claire. And thank you for bringing that up. I know on Monday, the Jackson County Legislature, they're going to talk about making the assessor into an elected position and putting that on the ballot. Will that go on the ballot this year? I don't know, because Frank White's going to veto. I believe Frank White will veto that request. And if Frank White vetoes that request, then the Jackson County Legislature will need 6 votes in order to put it on the ballot. Will they be able to get the 6 votes? I don't know. I don't know. And so yeah, I mean, the only way for us to get an elected assessor is either the Missouri state government change the statutory requirements that takes away the fact that that our county assessor is that it's not appointed by the Jackson County executive, but is elected by the people, or if it's on the ballot this year, which I don't know if it will be on the ballot this year, because they will need 6 Jackson County legislators to vote to place this on the ballot. And I don't know if they'll be able to get those votes. Lisa says, Frank has to protect Frank as well as Gail. What happened to the buck stop here? That's a great question, Lisa. I wish I could answer this question very honestly, but I do not want to create more drama than I already have in this podcast. So I will say that yes. Yes. I wish that there was more. I wish that more people honestly put themselves not put themselves first. Like, these people in elected positions put the people first and then put themselves second. But that is a tough ask nowadays for anybody to do. And with Gail being county assessor, there's a lot of things with that, because Gail was made county assessor for a reason. And for the insiders, they know what that reason is. And Frank White's not going to fire her. Oh, Lisa says it was rhetorical. Thank you for trying not to get me in trouble, Lisa. Dana asks, how can all this work be for not over one conversation? Dana, was it one conversation? That's the first question. Was it one conversation? We don't know. We don't know. And what was said? We don't know. Will we ever know? I don't know. But yeah, this deposition got Andrew Bailey scared enough to completely dismiss this entire case with prejudice. The only case that he reasonably had a chance to win before this election. And he dismissed it. Yes, Lisa, because politicians be politicizing. I agree. And it's sad, man. It's sad all that time. And the briefs that I reviewed with you guys that were made between June and August, honestly, those briefs were probably over 100 pages. So you were talking about over 100 pages of people writing legal arguments, okay? That's a lot of work over this one issue. And yeah, this case was dismissed because of Sean Smith's communications to Andrew Bailey, and whatever was said between Andrew Bailey and Sean Smith got Andrew Bailey scared. And that's what we have, man. That's what we have. Because like I said, William Webster was sent to jail for 2 years. Okay? For violating these federal and state statutes. Okay? So, did Andrew Bailey violate the law? Were these communications actually innocent and was just a passing comment? We will never know. I mean, I shouldn't say we will never know, but at this time, we don't know. Lisa states, as I tried to explain in the various groups, we will be lucky to see a credit at the end of this year and a reconciliation by escrow accounts. Yes. Yes. If we see a credit, I mean, that's a half win. A full total victory would have actually to see accountability from the Jackson County government and from Tyler Technologies. But if we see a credit, that would be a win. Dana says, thank you so much for all your time and energy, keeping this issue real for all the Jackson County residents. Yes. And I have to say again, the local news, besides KCTV5, Angie Racono, and KMBC, right? No other media company has been covering this case. The only time when they started covering this case was when the whole Andrew Bailey situation transpired, right? But a part of me is just kind of like, screw Andrew Bailey. Historically speaking, this was the biggest case in Jackson County history. They should have been covering this case from day one, and they failed to. And that just shows a failure of our local media. So it's my privilege to provide you guys with information the best that I can do. That I'm not a journalist. I'm an attorney, but I'm trying my best to keep the public informed, because our local media sources are failing us. And also, if anybody has time, please send here's a shout out to Angie Racono. She's been fighting this with the people since 2019, folks. And so you should, if you have time, you should say a thank you to Angie Racono too, because besides Angie Racono and a KMBC reporter, there was no other news media source in those courtrooms on those days. So if nobody has anything else to say, I'm going to conclude this session of Let's Talk Jackson. I'm sorry I'm not able to conclude this on a higher note. I was actually getting really excited for August 9th because that was a continuation of Gail McCain Beatty's her testimony on the stand. And I at least wanted to see a fragment of accountability, and we're not going to get that now. Kate says, my opinion on Gail McCain Beatty has something on Frank White. I have no comment on this. I have no comment. Lisa says, thank you. Thank you, Lisa, for watching this. And thanks everyone for watching this. And if you can, please share this to your community groups for people who want more information about what happened. But one thing I really want to tell people is, because I do not want people to fall into this trap of manipulation that's going on right now. The State Tax Commission's order was not a win for us. That's my opinion. It was not a win for us. And yes, it will remedy a lot of people for not paying insane property tax assessments if it's allowed to stand. But a win for us would have been accountability by the Jackson County government and by Tyler Technologies. And we're not going to have that now, not because of the facts of this case, not because of the Missouri laws, but because of the communications that happened between Andrew Bailey and Sean Smith. And that should make everyone mad. Claire and Kate says, thank you for putting this together. Thank you guys for watching, because you guys are the voice of Jackson County. And if you guys could spread the message, that would be great, because every property owner in Jackson County should have access to this information, because we don't need the spin. We just need somewhat of the facts of what's going on. And I feel that right now there is a spin going on in media where the Jackson County legislature is like, oh yeah, this was a win. No, it was not a win. It was not a win. And if the state tax commission's order is not held, then we have no recourse at all. So yeah, with that said, I'm going to end this live for Jackson County, for Let's Talk Jackson County. I'm going to be monitoring the news this week, so if I see something that compels me to do another live, I will let everyone know that I'm going to go live and what day it's going to be. But otherwise, I hope you've been enjoying my coverage on the Jackson County trial. I wish things were different, but this is what we have. But I'm so grateful for my viewers who want to be educated about this. So if you can, please share this with your groups. And I hope you have a very lovely Sunday evening. Lisa states, I would recommend anyone who can watch the legislative meeting tomorrow at 3 on the Jackson County website. Yes, I would too. Definitely watch tomorrow's meeting. They're going to bring up the assessor issue, and they might bring up the chief's tax issue, because right now they're trying to put the chief's tax question back on the ballot this year. So it's going to be entertaining, to say the least. It's going to be entertaining. There's going to be a bunch of posturing, a lot of emotional arguments. I'm just saying, you guys, just see through the emotion and just focus on what's being said, okay? Because, like I said, there's so much manipulation going on right now as to what happened, and what happened was a colossal failure of the Attorney General's office and of Sean Smith. Oh, Lisa says, also recommending that Jackson County legal not fight the order. They don't have that authority. The Jackson County executive only has that authority. So they can pass a resolution, and this is a great point you bring up, Lisa. They could pass a resolution to say that they're recommending the Jackson County, counselor's office to not fight the order, but they don't have authority to direct the counselor's office not to fight the order, because that authority is only with Frank White as Jackson County executive. So that's all we have. Hopefully in 2026 we can have a better county executive, but that's what we have right now. So even if the legislature passes this resolution, it's nothing but a piece of paper, and it's not going to have any weight or standing to do anything. Yes, it is good info. Yes. Well, thank you, Lisa, for asking all the questions. Would I run again? I'm planning to run again, and I'm saying that because I have been telling people I'm planning to run again in 2026, but I will most likely make it official in 2025. But I am planning to run again. I'm not raising any money right now, okay, people, but I am planning in my mind to run again for 2026. So spread the word. There is going to be competition in 2026 because we really need to change, folks. We really need to change. And in 2022, I tried so hard to make this change happen. Okay. And I wasn't able to, but hopefully in 2026, it can happen. Frank must go. Yes, Frank needs to go. Other people also need to go too, but Frank definitely needs to go. I agree, Lisa. Anyways, have a good day, everybody, and have a wonderful evening. And thank you again for watching this session of Let's Talk Jackson.